Well, as people continue to take their seats, let's get started. My name's Adam White. Welcome to the Center for the Study of the Administrative State here at George Mason University's Antonin Scalia Law School. It's my pleasure to welcome all of you here today, speakers and audience, as well as people watching the video. The Center for the Study of the Administrative State, for those of you who are new here, was founded about 2 years ago by Professor Naomi Rao, who created this center with the idea that it would be good to have a home for scholarship and discussion of administrative law and regulatory policy here in the Washington, D.C. area, a place where we could connect ideas and the policy debates that seem to be happening in administrative law and regulatory policy in all three branches of federal government right now. We've seen for a few years now in the judicial branch, the executive branch, and in the legislative branch, debates over the proper relationship between federal agencies and the other parts of government, the relationship between regulatory policy and discretion, and the rule of law. And Naomi, again, founded this center as a home for scholarship and debate on these issues. Now, Naomi, in case you haven't heard, has gone on to other things. She now is playing a first-hand direct role in these issues, now as in the White House as Administrator of the Office of Information and Regulatory Affairs. And so it's my great pleasure to inherit the center from her and to continue its work. And the topic today is literally continuing her work. Naomi picked this topic months ago before leaving George Mason's Law School to head to the White House. And so I've had the pleasure of continuing this project, which proceeded in two steps. First, a private workshop a few months ago where the authors today had a chance to discuss and debate the drafts of the papers we're discussing today. And then now with this public discussion, which we hope will expand discussion and dialogue of the subject and bring some more voices to these issues. And so we look forward to a day of debate and discussion, hopefully some arguments, and hopefully some learning along the way. So thanks again for everybody for joining us. Now the topic, just very briefly, I want to say, Naomi chose the title very carefully, Beyond Deference. For the last few years, discussions of judicial review of agency action, administrative law, have focused in large part on issues of deference, Chevron deference, Seminole Rock deference. And those are, of course, important. But Naomi and I both found that it was very important to also focus on other aspects of judicial review of agency action, which probably haven't gotten enough attention while all of us lawyers and law professors have been shouting about Chevron deference. And so I couldn't be happier with the papers that the authors today have published or have produced. I hope you'll look at them on our website for the page for this event, because you'll find 5 papers on very important and interesting aspects of administrative law that I hope will have an impact in the debates that continue. And so without belaboring the point any further, let's just move on to our first panel. It's titled First Principles and Second Thoughts, What is the Current State of Administrative Law? I'll introduce the speakers one at a time as it's their turn to talk. So let me just begin with our opening speaker, Jeff Pojanowski. Jeff's a professor of law at Notre Dame's Law School, teaching and writing on administrative law, jurisprudence, torts, and legal interpretation. He'll kick things off today with a discussion of his paper on what he calls neoclassical administrative law. Jeff?
Do I go here or up there?
Whichever you...
You guys want to stay here?
I'm going to.
All right, all right, I'll go up there then. All right. Well, thank you, Adam, for having all of us here. This is a great event and an exciting conference, and we're grateful for your generosity. And thank you, everyone, for coming here. So, one way I started thinking about my paper is I started thinking about the state of the field in administrative law, and you tend to see 3 camps as kind of a rough cut of how people are thinking and arguing about administrative law. There's one camp we can call administrative skepticism. This is Philip Hamburger and the kind of root and branch critique of the administrative state, largely on constitutional grounds. And you can have the flip side. Adrian Vermeule's approach, what we call administrative supremacy, where there's kind of a Thayerian or Landis approach to, the administrative state is supreme, and lawyers, for the most part, should get out of the way and patrol for reasonableness at the margins. And then there's a third approach, which is by far the biggest and the most popular, which we can call accommodation, where the administrative state has we want to patrol, we want to defer on law, but not too much, or not all the time, or sometimes. We want to largely stay our hand on review of policy, but again, not too much. It's kind of a third way in between the skepticism of the Hamburger contingent and the kind of the radical deference of someone like Adrian Vermeule. And this has been kind of the standard science of administrative law for the past 30 years. But as evidenced by people like Vermeule and Hamburger, there's some sniping at the center. And it's time there's an opportunity to kind of to rethink or to think afresh how we're doing things. And I'm posing and thinking about a fourth way of doing it, which I guess for lack of a better term, I'll call neoclassical administrative law. It's classical in the sense that it adopts some of the interpretive formalism of people like Hamburger. They believe in the belief in the autonomy of law and distinctively non-legal realist when it comes to interpreting law. But it's neo in the sense that, unlike Hamburger, it is resigned, or at least reconciled, or at least resigned to the constitutionality of the administrative state as a whole. We're not, they're not here to blow up the entire edifice. And if you read Gillian Metzger's recent foreword, she makes the point that for all the Sturm und Drang about the administrative state, most of the changes have gone on the margins. And what would a critique of the administrative state that doesn't blow up the edifice look like? And maybe so this is partially a theory of I'm kind of developing on my own, but it's also partially pulling together threads of what I see going on in the courts and with scholarship. And so three kind of basic commitments of what I call this neoclassical approach to administrative law. The first, which I've kind of flagged to you already, is a belief in the autonomy of law and its distinction from policy. Modern administrative law blurs the two. That's why we have Chevron, for example. But if you have a more classical understanding of the autonomy of law, primarily through a kind of interpretive formalism along the lines of textualism or a formalist approach to intentionalism, you might very well reject the way Chevron blurs the line between law and policy. Now, that doesn't mean it's law all the way down. Part of recognizing the autonomy of law is that there are domains of administrative policy making where legal tools run out, and their courts properly should stay their hand. But the neoclassical formalist approach might say the law runs out later than a Chevron believer would. Second commitment would be the primacy of positive law over judicial doctrine. This doesn't mean judicial doctrine is never justified, but if there is positive law on a matter governing administrative law, it should trump. And this would largely, and one output of this would be taking the APA more seriously than contemporary administrative law does, and understanding it and given the formalist interpretive commitments of the neoclassicist, reading the APA in a kind of originalist fashion. And the third aspect would be what I call constitutional moderation. That we are not, even if you're an interpretive formalist about the APA, an originalist about the APA, and even if you are sympathetic to the idea that the administrative state is not justified by the original Constitution, you're not going to go that far and blow it up. We can almost kind of look at this as a kind of meta-accommodationist position. We'll be an originalist about the APA. We'll be accommodationist about the Constitution, and that is, and so that would be the third point. So, what would this look like, and would it be appealing? And again, these are tentative conclusions. But and a lot of this will depend on what, in fact, the APA truly says. And I think Ron will we'll talk about this a little bit. But some of the outputs of this approach we can look at it through four domains of judicial review: questions of substantive law, questions of procedure, questions of policy, and judicial review of factual findings. I'm inclined to believe that on questions of law, the APA points towards something like de novo or a Skidmore-ish kind of review. So the neoclassical administrative lawyer would be inclined to reject Chevron and our deference. And that doesn't mean the judges get the last say on every question that comes in front of them. We're going to carve out the distinction between review of questions of law and questions of policy. But a lot of the stuff that we would call Chevron Step 2 would be properly dropped into an arbitrary and capricious box and not be treated as a question of law. And that's on dealing with agencies' substantive provisions. And then there's a question of procedure. And here, I think practice would be contemporary practice would be mixed. It would uphold Vermont Yankees and Perez versus mortgage bankers' understanding of the APA. And on the other hand, it might call into question the more rigorous impositions of notice, in informal rulemaking, and statement of basis and purpose to the extent they're in tension with the APA. There's got to be, we can talk about the extent to which that's going to be, but it'll be a mixed bag, I think, arguably be a mixed bag for agencies under this approach. And then the third would be questions of policy. And here's where I think the neoclassical administrative lawyer is different than a Hamburgian skeptic. If to the extent, rational basis review was pretty close to the model of what arbitrary and capricious review is supposed to be for policy. To the extent that the vigorous, hard look approaches to review of agency policymaking maybe have to be dialed back a bit. And this kind of hangs together pretty well with the formalist recognition of the divide between law and policy. And when the statute says, be reasonable or do something in the public interest, and if those are not legal terms of art and the lawyer's tools run out, and if you have reason to believe that the original APA didn't want something like hard look review, the courts might stay their hand. And as a practical matter, I think Adrian Vermeule's made a decent argument that much arbitrary and capricious review on the ground is actually reasonably light touch, and there's only State Farm would maybe the exception rather than the rule. And then there's review of questions of fact to the extent universal camera correctly gets the mood of what judicial review of facts is supposed to be like, then we might not have much changes in that respect, but we'd have to do the digging. Am I doing on time here? I'll briefly kind of flag a couple potential objections that we can talk about. I only have a minute left, but there's three, at least three kinds of objections we can think about this one. The first one is it's naive or anachronistic. If you reject the neoclassicist rejection of legal realism, you're not going to be happy with this. I've got some answers for that. We can maybe talk about that in the discussion with Ron. But it's a serious objection. The second would come from the other side, the charge of faint-heartedness. If you're an interpretive formalist, why are you being that way about the APA and not about the Constitution? Why not follow the strength of your convictions and blow the whole thing up if in fact that's where you think it goes? I'm not sure if that's where it goes, but that's a third objection, or second objection to think about. And then the third is going to be transition costs. If the APA didn't originally, as understood, didn't expect the amount of informal rulemaking we have, and the procedures are stripped down to largely if the procedures are so bare because they didn't think agencies would be doing it, they thought they'd be using formal rulemaking. Isn't the current dispensation better? And then the general arguments in favor of stare decisis and upsetting the doctrine, and that's something I think we can talk about when I'm not using my 10 minutes. So that's a proposal here. I think it goes along with it's roughly consistent, at least in practice, with a lot of the critics of the administrative state. They chip away on deference and law. They embrace Vermont Yankee. It's hard to generalize about what they do with respect to review of policymaking, but they tend to not blow up the whole thing. And this might provide an explanation and a normative argument for why that might be the best settlement. And it's at least one I think worth considering as we look to the future of administrative law, which Aaron will talk about later. So thank you very much.
Thanks, Jeff. Our next speaker is Ron Levin. He's the William R. Orthwein Distinguished Professor of Law at Washington University School of Law, teaching and writing on administrative law and other public law issues. He's co-authored the casebook State and Federal Administrative Law, among many other books and articles. I'll add, I've had the pleasure of serving with Ron on the Leadership Council of the American Bar Association's Administrative Law section. And so it's my great pleasure to welcome you here today. Thanks, Ron.
Okay, thank you, Adam, and good morning, everybody. Adam enlisted me to be the devil's advocate or the heavy on this program to critique Jeff's paper, so I'm going to overcome my normal tendency to be sweet and inoffensive and make a couple of critical comments about what he calls the neoclassical administrative law model. And to frame this up, I want to look at some of the ways in which the Administrative Procedure Act has been creatively interpreted since its enactment, which has been dramatic. We've seen the rise of rulemaking because of the enactment of statutes that required standard setting, and just because it's more efficient and effective in a large society as we are becoming. And with the advent of rulemaking has also come interpretation to put safeguards on that process with a beefed up 553 understanding, with a rulemaking record which was not contemplated in the original model, with serious judicial review of the facts underlying the rulemaking. If you were to go back to the understanding in 1946, a court would look at the facts and just ask whether there can be some rational basis conceived for its underpinnings, because there was no rulemaking record. But I think today we would look at that as fairly essential. Think also about the broadened interpretation of standing under the APA, which serves to protect beneficiaries of regulation along with regulated parties. All these things, I think everyone would agree, happened, and I think probably most of us would say they had to happen in order to keep up with development, but not very compatible with an originalist, static notion that I think Jeff is promoting. Now, you may say, well, the courts didn't have to do all this. They could just have left the updating job to Congress. I think we have 70 years of experience that shows how unrealistic that argument would be, because in most of that period, Congress has been indifferent to administrative law reform, either because they suppose it to be boring, go figure, or because there aren't many votes in the kind of reform that I'm talking about. Yes, we do have periodic movements such as today in which Congress does take an active interest, but these seem, at least recently, to be one-sided, divisive, driven by economic interests. I know there are people in this audience who favor the Regulatory Accountability Act and other measures of that kind, which we could debate, but I think even if you do take that view, it's just not the same. It's a far cry from supposing that Congress could take on the whole job of bringing the APA into line with developing realities, making judicial creativity superfluous. So with all that as a prelude, let me look more directly at Jeff's proposal for what he calls APA originalism. I think one of the leading themes, as you've just heard, is putting a good deal of faith in positive law, specifically the APA. And I think one of the limitations of that notion is that a number of the arguments he uses to support his originalist proposals are quite argumentative interpretations of the APA, speculative, I would say wrong in some cases, but surely debatable. And to the extent that's true, you need something beyond just a commitment to history, to fidelity to Congress, in order to justify one interpretation as opposed to another. Let me give you a few examples of some arguments that I consider debatable or worse. One of Jeff's positions here in this paper and some earlier ones is that the APA Section 706 should be read as requiring de novo interpretation of of the law, no deference allowed. He draws on some other authors who take the similar position. I think there are a number of arguments to be made about that based on legislative history and textual exegesis and the like. But let me just, for now, just make you an originalist argument as to why that's not true. When you talk about constitutional originalism, you're usually talking about going back 200 years, sorting through the mists of history and figuring out things that very few of us have any direct knowledge of. But when you're talking about 1946 legislation, there's a ton of legal materials available in your law library or your electronic equivalent that shows how people of the time understood the law. Well, so what was the response to Section 1986, to Section 706, when it was adopted? The answer is the courts went on deferring exactly as they'd been doing before the act was passed. It had no impact whatsoever on doctrine, and I think that's because people of that generation understood that the intention of Congress here was to adopt very general criteria that would leave plenty of room for courts to read it one way at one point and probably other ways in other points in history. Let's take a second example. Jeff has a take on the Seminole Rock case, enters into the Auer v. Robbins debate by saying that really Seminole Rock was understood to be narrower than we now understand Auer to be. And Congress codified that narrower interpretation in the APA. Bowles v. Seminole Rock came down in 1944, and the APA was passed 2 years later. And what was that narrow interpretation? Well, he says that it was really just an application of the Skidmore test, which seems a little unusual at first because they aren't worded the same way. But he says, no, actually, there is a similarity there because for a couple of reasons, but one is that when Henry Hart was in the SG's office, he argued this case to the court, and his brief cites to Skidmore as an authority, and that definitely is true. Hart's brief says that the administrator's construction cannot be ignored even when it involves only the administrator's views as to the meaning of the statute under which he is operating, citing Skidmore. Then Hart goes on to say, the weight to be given to his construction of his own regulations should obviously be much greater, for then he's explaining his own intention, not that of Congress. So Jeff, I think, seems to interpret obviously much greater as tantamount to pretty much the same, which I think is kind of a stretch. But even if you accept that proposition, if Congress codified Seminole Rock, it would not have known about Henry Hart and the secret history. It would have known what U.S. reports articulates as the test for judicial review, which is identical to what Justice Scalia relied on in Auer v. Robbins. So there are plenty of issues to debate about Auer deference, but I really tend to think the originalist critique is not a helpful one. So suppose we look past the history and we say, okay, history may be debatable, but is there any functional justification that underlies Jeff's model? And I think what he would say, and what we heard a few minutes ago, is that he would draw a sharp distinction between law and policy. Judges can go quite forcefully in applying law, but they should leave policymaking to the agencies. They don't really have the competency to deal with it. I think a difficulty with that is that it won't really be feasible to separate laws and policy as he contemplates. And one reason is that even when a court gets to the arbitrary capricious level of review, I don't think it's the case that law ends, because the job of the court is not to decide whether the action is reasonable in the abstract, it's to decide whether it is a reasonable application of the statute, and that often means asking whether the agency applied the statute conscientiously and persuasively. This is totally orthodox doctrine because the goal of arbitrary capricious review, we are told in the cases, extends to a consideration of whether they consider the relevant factors. Think about the State Farm case, in which one of the reasons why the rescission of the seatbelt rule was impermissible was that the court suggested that NHTSA had not paid much attention, sufficient attention, to the safety mandate of the legislation. So law is involved throughout the process, and I think it's quite hard to draw a hard separation between them. So to sum up, I think there may be a place for formalism in administrative law, but I think the APA originalism project does not have the historical solidity or the functional rationale that would give it a bright future. Thank you.
Ron, as you introduced yourself as the devil's advocate, I spent a couple of minutes trying to ponder who the devil in this scenario is. So our next speaker is Richard Pierce. Richard is the Lyle T. Alverson Professor of Law at George Washington University. He's written over 20 books and 130 articles on administrative law, regulation, and agency performance, including a case book that he co-authored with another of today's speakers, Kristen Hickman, and the truly indispensable administrative law treatise. Dick, thanks for joining us today.
Thanks, Adam. So I've got two ways of thinking about the current state of administrative law. One way is to think about the current state of the doctrines. It's a confused mess. What we've got is at least 2 versions of Skidmore, at least 5 versions of Chevron, a constantly changing our doctrine. And I have to say, I pity the hundreds, thousands of law students who are today studying for their administrative law exam and sitting there anxiously trying to figure out, well, how the hell do I state the doctrine I'm supposed to apply in this stupid exam question? And from their perspective, it's a terrible, terrible state. From my perspective, it's not bad at all. I'm pretty happy with it. Okay? So Kristen and I write this treatise, which means, for better or for worse, we got to read all the opinions. Every damn opinion that comes out from a circuit court, we read. And every doctrine, every one of these variations of Chevron and Skidmore and Auer that I read, and every opinion I read has these characteristics. First, every one of them requires the agency to anchor its action in the language of a statute. Second, every opinion requires the agency to support its action with evidence in the record. Third, every opinion requires the agency to explain its action adequately with reference to the language of the statute and the evidence in the record. Fourth, courts attach increasing significance to continuity, and they increasingly require more of an explanation when the agency departs from a prior continuous course of action or policy than when the agency is just making an incremental change or adhering to a settled policy. Now, the court actually rejected that approach. The majority did in 2009 in the Fox television case. But in 2016, in Encino Motors, the court quite clearly said, no. We're going to require heavy-duty lifting to convince us that you have looked carefully at the need for a change in your policy. And that, I think, is really crucial these days, given the tremendous political polarity that we have. If we're going to have something like Chevron that confers quite a bit of deference, policy-making deference on the executive, then I think we have to temper it with a heavy dose of a required explanation for every change. So we don't just have, every time there's an election, flip. Every damn policy goes from bright red to bright blue or in reverse. We got to have some tempering process. And so I think the Encino Motors emphasis on heavy-duty explanation for a decision to depart from a settled policy, settled course of action is very important. The Barnett and Walker study that recently came out in Michigan found that circuit courts uphold long-standing agencies' policies far more frequently than new or changed policies. So even though that study found that courts, when they apply Chevron, far more frequently uphold agency actions than when they apply Skidmore, it also found that when agencies uphold, when courts uphold agencies through application of Chevron, they do so far more frequently when the agency is adhering to a long-standing policy than when it is changing a policy or announcing a new policy. Well, that's a strange version of Chevron. That's actually a version of Chevron that sounds a hell of a lot like Skidmore. And if you go back and you reread what Justice Breyer wrote in Barnhart versus Walton, and remember, Justice Breyer always hated Chevron. And what he tried to do in Barnhart v. Walton, and succeeded to a good deal of extent, was he said, this is a Chevron case, and here's what Chevron says. And then he repeated and applied the Skidmore test. I think that's a lot of what's going on. And I think if we're going to have Chevron, we need to complement it with a heavy dose of the requirement of adequate explanation, and particularly heavy burden of explanation when you're changing course. And then courts continue, in every opinion, they confer appropriate deference on agencies. Deference is never going to go away. It's always been there. It's always going to be there. It makes no sense to try to eliminate it. You're talking about an agency that deals with the statute every minute of every day versus a judge that pops in once a year and says, what's this statute about? Okay? And then you're talking about an agency that has often spent hundreds, thousands, sometimes tens of thousands of hours trying to work out a problem. And I'm not suggesting that the answer should be, well, they worked on it, so and they're the experts, so we're going to approve it. No, and that's not what any of the courts are saying in any of these opinions. But you start there, you read it with respect, and then you figure out what to do with it. And you figure out what to do with it by seeing whether it's anchored in a statute, whether it's supported by the evidence in the record, whether it is adequately explained. And every opinion does that. So I wind up pretty happy. I like to participate in these because I have opinions. I think, this way of doing it is a little better than that way of doing it. And when I lose, I don't care that much. As a citizen, I'm still happy.
All right, and our final speaker today is Aaron Nielsen. He's an associate professor of law at the Brigham Young University Law School, where he writes and teaches on administrative law, civil procedure, federal courts, and antitrust. You can also find his analysis on the D.C. Circuit every Friday on the Yale Journal on Regulations blog. Notice and comment. I can't recommend it highly enough. Aaron, I hope you're also happy with the United States.
Well, it's hard to follow Dick. That was remarkable. So let's see what we got here. I'm going to try to give the future of administrative law in 10 minutes. We'll see if it can be done. There's a question mark here. The answer is yes, there's a future. But what that is, I think is going to be interesting. So here we go. I think the key to understanding where the court is going with administrative law is City of Arlington, FCC City of Arlington, which on its face doesn't seem all that important. The question was whether or not agencies should receive deference on jurisdictional questions. And most people thought, well, the answer is yes. Leading up to the opinion, the D.C. Circuit had said the answer is yes. The leading treatise, Dick's treatise, had said the answer is yes. And the Supreme Court said the answer is yes. Justice Scalia, writing for the majority, says the idea that there's this difference between jurisdictional and non-jurisdictional questions is a false idea. It's a mirage. There isn't a difference. They're all the same. Agencies receive deference to the extent the statute's ambiguous, and to the extent that it's not, they don't. And the idea we're going to carve off jurisdiction versus non-jurisdiction is silly. That is all predictable, and it was predicted. What's interesting about this case is the Chief Justice's dissent. The Chief Justice's dissent includes some of the strongest anti-administrative rhetoric I think you're going to find in the Supreme Court reporter. Here, this is a piece of it, but he says at the end here, I guess I don't have a laser, but the accumulation of these powers in the same hands is not an occasional or isolated exception to the constitutional plan, is a central feature of modern administrative American government, and he goes on from there, to which Scalia responds. Footnote 4, the Chief Justice's discomfort with the growth of agency power is perhaps understandable, but the dissent overstates when it claims that agencies exercise legislative power and judicial power. The former is vested exclusively in Congress, the latter in one Supreme Court, and agencies have been doing things that look like legislative or judicial power forever, to which the Chief responds. What the court says in footnote 4 of its opinion is good and true, except, of course, for the dissent overstates part. The framers did divide governmental power in the manner the court describes for the purpose of safeguarding liberty, and yet, ellipsis in the original, the citizen confronting thousands of pages of regulations promulgated by an agency directed by Congress to regulate, say, in the public interest, can perhaps be excused for thinking that it is the agency really doing the legislating. Where are we? We're going to come back to the city of Arlington, why this matters, but where are we? How did we get here? I'm not going to go too deep into this, but we've had a fun history of administrative law where we've had a lot of changes over the years. Before 1887, this is contested, but I think it's fairly fair to say that it was different than how things are now. There's a lot more formalistic divides between powers. Certainly in terms of volume of federal administrative action, it was much smaller. The first big modern agency is the Interstate Commerce Commission, 1887. And at that time, there were significant restraints on what they could do. I think it's interesting that before the ICC could act, it had akin to a full trial with evidence and all sorts of things in a trial-like setting. Why? Because there was apprehension about this new form of governmental entity. Fast forward to the New Deal, and James Landis, who had a very different idea, borrowing from Woodrow Wilson, that, a quote from Landis, one of the ablest administrators, I believe, never read, at least more than casually, the statutes that he translated into reality. And that was not a critique. That was, he thought, is a good thing. We want to have agencies that are run by experts and not lawyers. And we certainly don't want them run by politicians. That prompted a backlash in the 1940s, which led to the APA. The APA was a fierce compromise, in George Shepard's words. Now we kind of think of APA, who doesn't like the APA? It's apple pie. At the time, it was quite controversial. It was unanimous in the court, in Congress, but that was because everybody's giving up something. One of my favorite quotes is, it was attacked at the time as nothing short of a sabotage of administrative process. Fast forward again to the Reformation. This is the 1970s. True story. American administrative law changed because of peanut butter, for reasons that we can talk about in the Q&A. The 1970s, very interesting time in administrative law. In some ways, agencies become much more powerful. In other ways, they become much more constrained. But the difference of the kinds of restraints changed. Fast forward to the 80s. We get the Counter-Reformation, the 80s and 90s, where, again, things changed. A lot of administrative law is brought into the White House, expanding presidential power, at the same time imposing cost-benefit and things of that sort. And for a long time, this is really where we are. We've got Reagan and Clinton. I don't know what Reagan is joking about. It must be really, really funny. But for a long time, that's really kind of where we are. And now we're starting to see some tension around the edges. With that backdrop, understand the court. This is the Chief Justice's concerns. Agencies exercise what appears to be legislative power. We talked about, he thinks, if it's regulating the public interest, come on. that's really legislative power. We just don't call it that. The backdrop of this is Yackas and cases like that, where they say generally fair and equitable. That's a fine, intelligible principle. It's not even has to be fair and equitable. It's just generally fair, more or less fair. That's all right. Fast forward to Chevron. The court will even infer delegation. We live in a world of delegation everywhere. Is the fight over? I don't think the chief thinks the fight is over. I think the chief thinks, you know what? Sure, there's delegation, but I'm going to require a clearer statement from Congress, and if it's a really important thing, I'm not going to defer, and I'm going to be wary of whether Congress authorized it. So see his dissent in City of Arlington itself, also see his majority opinion in King v. Burwell. Other cases, I think there's a lot of discomfort in the chief about where we are with this. The chief's next concern, agencies exercise what appears to be judicial power, which is true. Agencies are always adjudicating things all of the time. They have judges this last week. The chief had snide remarks about when they said there's administrative law judges. He's like, what are these judges of which you speak? Usually when we mean judges, we mean something other than that. Background on this, Crowell v. Benson, private rights sometimes can be adjudicated by agencies. CFTC v. Shore, common law rights, the courts will let agencies sometimes adjudicate them. I don't think the chief is comfortable with this. And I'm basing this on Stern v. Marshall and his dissent in wellness, which, again, the rhetoric in wellness is extraordinary. You should certainly give that one a read. So I think he's going to allow adjudication of public rights, but much, much more wary of adjudication of private rights. See the oil states argument from last month. I think we're going to see some movement there. Next, his next concern is agencies appear to be exercising executive power without the president. He's worried about the headless fourth branch. Background here, Humphrey's executor. You can have independent agencies. The court said so in the 1930s. The chief is wary of that. See Free Enterprise Fund, where he wants to put double for cause removals. See the PHH litigation, where I think Judge Kavanaugh thinks the court is going to be unwilling to go all of this power in a single-headed entity. We'll see if that ever makes it to the court. I think the Chief Justice would be receptive to that sort of argument. So what's the fight? Accept what we have now, but no further extensions. No more than what we already have. The final concern of the chief, the administrative state is just too powerful. Again, read City of Arlington. He goes on and on and on about the power of the administrative state. I think it leads to this. The chief is not looking to overrule major cases, but he wants to cabin some of them. In other words, stare decisis matters to the chief, but that does not mean that ideas he thinks are wrong must be amplified or extended. Now, at this point, you're probably asking yourself, well, that's all well and good, but why do I care about a dissent? The chief is the Chief Justice, that's important, but why do I care? Because the Chief Justice was joined by two other of his colleagues in that dissent, in full by Justices Alito and Kennedy. Kennedy sometimes is left off of lists as those who are skeptical about the administrative state. He's here in some of the most aggressive rhetoric the court has issued on the subject. He wrote Encino. He joined Stern v. Marshall. He joined Free Enterprise Fund. He's with the chief on these matters. Justice Thomas was in the majority of City of Arlington. He has now gone beyond where the dissent is in the City of Arlington dissent. So you've lost one vote. And finally, the author of City of Arlington, Justice Scalia, of course, has been replaced by Justice Gorsuch. And I suspect, based on what Justice Gorsuch has said, that he's going to be closer to Thomas than he is to the chief. But add it up, and we've got 5. And with that, I think that's where the future of administrative law is heading.
I mean, before we get into the real substance of the discussion, I have to ask, peanut butter? Could you just give us the 1-minute version of why
Okay,
peanut
all right.
butter was the defining moment of administrative law in the 70s?
more than the 70s of the nation. In the 1960s, the FDA wanted to decide what content of peanuts are in peanut butter. And the FDA did this through a formal rulemaking process. We talked about informal rulemaking. There was a formal rulemaking process, which was again akin to a trial to do this. And it took something like a decade for them to be able to do that. And everyone's like, this is ridiculous. How can we make agencies spend a decade to figure out how long the so pressing question, is it 94% or 97% or whatever of peanut content, at which point there's some reason to think that that's caused some of the changes in the 70s about how we approach the rulemaking questions.
I can answer that a bit because I might be 1 or 2 years older than Aaron. I know we have a couple of folks from the Federal Energy Regulatory Commission here, but you're way too young to know how your predecessor, the Federal Power Commission, operated prior to the Supreme Court's 1972 opinion in Florida East Coast. I was practicing in Washington at the time that opinion was handed down, and at the time, all of us went running up and down the corridors of the law firm saying, "Oh, the world has come to an end! How are we ever going to survive?" Because what we were doing was we were living on what the Supreme Court had by then characterized in 3 different opinions as nigh interminable hearings. It wasn't just the peanut butter case. It was, oh my God, the Federal Power Commission alone. The second floor was devoted to the hearing rooms, and that was referred to as the storage rooms, because those hearings went on and on and on. What you did was you put an associate in there. There were typically about 100 parties and about 200 witnesses. And this poor ALJ would sit there and say, okay, let's see, what day does this? Okay, we now have, we have lawyers 31 through 36 will cross-examine witnesses 42 through 44 today on day 612 of this hearing to determine what to do about a problem that in the meantime has been resolved naturally. That's the way things worked until the Supreme Court held. It wasn't just formal rulemaking, because before Florida East Coast, whenever the statute said you had to have a hearing and you conducted a rulemaking, the hearing was interpreted to require an oral evidentiary hearing. Okay? It was only after Florida East Coast when the Supreme Court held that hearing is ambiguous and in the context of a rulemaking can be satisfied by notice and comment, that agencies like the Federal Power Commission and other agencies said, oh, we don't have to have this storage area on the second floor? And law firms said, we have to figure out something to do with all these associates. That we said, you know, my instructions always, I did this for a couple of years, and my instructions always were pop up and make an objection every day so we could prove to the client that we had somebody there and we can justify the 8 hours billed hours for every stinking day of that nigh interminable hearing. So it wasn't just peanut butter.
Okay, and now we have administrative law in a jiffy, so that's great.
Hey, how about 6 to 8 years?
So I want to give the panelists a chance to sort of discuss what's already, weigh in on what's been discussed so far. But I do want to start with Jeff. If you have any thoughts on Ron's criticism, other points that were raised, and I would like you to just sort of give us an example, if possible, of who would be a good neoclassicist currently on the scene. Is there a scholar or a judge who you think comes closest to this sort of this new school that you're identifying?
I mean, I guess probably the closest one I would think of would probably be Brett Kavanaugh, in the sense that in some of his extrajudicial writings, he's been skeptical of Chevron, and he's a formalist. He's an interpretive formalist. But he stands behind Vermont Yankee, and he has questioned whether the D.C. Circuit's unwillingness to extend Vermont Yankee type reasoning to other aspects of the informal rulemaking is justified. So there you see the deference skepticism with respect to legal interpretation, but not manifesting itself as a purely against the agency all the time kind of thing. Sometimes if the procedures give the agencies more leeway, well, that's what the procedures give them. So that would be a crystallization of this. I don't know his arbitrary and capricious review jurisprudence well enough to see whether he's a light touch or not on that, but that would be one. That would be an example there that would distinguish him from maybe someone like Justice Thomas or something like that.
And do you have any sort of broader thoughts on some of the points that were raised?
Yeah. So I won't suck up all the oxygen, but I'll focus on the argumentative / speculative / debatable outputs that we discussed. And I guess my first point is. If these things I'm proposing, these outputs I'm proposing with respect to deference are wrong, well, at least I want to be asking those questions and figuring out, and if we're paying attention to what the APA in fact meant, I feel like we're in a better place, and we're in fact buying into the kind of presuppositions I have about what the law might possibly be able to tell me. So if in the end there's a good legal argument that the APA, the fierce compromise, points towards deference, and I become convinced, well, that's you follow it where it goes. But I'm happy to be having that discussion and having that argument. And I guess one particular point, I do want to kind of respond on the Seminole Rock thing with the obviously much greater point, because I don't think I'm stretching there. So when the brief says agencies get deference on interpretations of statutes, Skidmore, obviously they get much more here. One way of reading that is this is a different test, and this is obviously something stronger, and my interpretation would be wrong. But if you think of the premises of the Skidmore test, which talks about agencies' expertise, the reliability of their reasoning, all these kind of soft factors, they, to the extent they apply to statutes that Congress wrote, obviously they have much more persuasive force as a general matter with respect to a text that the agency wrote is nearly contemporaneously interpreting, and you have no reason to believe that they're kind of they're fudging things. So that's how I read it. But with respect to the point of the secret history, what matters is not that Congress was thinking about Henry Hart's brief, because they certainly weren't, but trying to kind of capture what was in the air at the time that these cases were being litigated to grasp what was becoming law. So I'll stop there rather than taking up all the time.
Did you want to jump in?
Well, I think that what was in the secret history probably is of limited importance. But if it is true that Seminole Rock was applied in a relatively narrow way and then over time applied in a slightly broader way, I see nothing illegitimate or questionable about that development. This is a precedent, a common law precedent, that probably Congress didn't codify one way or the other. My larger take is that Section 706 was simply viewed as a vehicle for development over time, restating what the courts had been doing, but not purporting to keep them from doing something else over time. And we can talk about a fierce compromise. It's certainly true that the APA was stimulated, the impetus for one, was stimulated by a backlash against the New Deal. But the APA passed unanimously because there was a reconciliation and ways to find common ground, and I think part of that compromise was agreeing to say nothing in Section 706 other than to list criteria and say, now go for them in one way or another. So if you put the codification aside, Seminole Rock has been reinterpreted over time. Well, so what? Each of the courts that reinterpreted it had the benefit of briefing and argument and ability to assess it. And if they thought that it was important to read it in other contexts than the one that they had originally contemplated, that seems a totally legitimate development, a natural part of the unfolding in administrative law. We can say Skidmore has been interpreted more broadly recently than it was ever originally contemplated. It doesn't speak to anything other than the Labor Standards Act, but people have thought it was helpful to apply it to other contexts as well. And in Meade, it was applied in a totally different, qualitatively different fashion from before, because Skidmore dealt with the situation where the agency had no rulemaking power. After Meade, Skidmore is also used in contexts where the agency has it but hasn't used it. Is there something fishy about that? Well, I've had my criticisms of Meade, but I think that's a legitimate development. Originalism doesn't work very well with regard to a case law development, and so whatever it was contemplated at time 1, if it turns out to be something different at time 2, 3, 4, 5, and n, I don't think that's problematic.
But I do want to step back for a moment and take a broader look at what's happening right now. I mean, it's my sense, or maybe my premise in helping organize this conference, that the debate that's happening at the moment, or that's been happening for the last several years, is different. It's different from what came before, that there's a more intense debate over some first principles, that there's more sustained interest, not only among members of the Supreme Court, members of the lower courts, in reconsidering some things, but also sustained interest on Capitol Hill. Now we've seen in the last, I guess this year, a White House issuing executive orders like the 2-for-1 deal and regulatory budget that are so orthogonal to the way we've been talking about administrative law for the last several years. Is my sense of all of that correct, that the debate we're having now is different, or is this just another iteration of debates that have been happening over and over again since '46 and earlier?
I agree with you. I think it is more intense. I do think it is, in a sense, symptomatic of this increased political polarization, or this. The one sense in which, well, I think what we're dealing with at the moment in terms of the process side of things, how you make decisions, how rulemaking in particular. I think the Trump administration, whatever the priors might have been of the lawyers who got into it, they have quickly decided that the notice and comment process is not easy and quick. They are doing everything in their power to avoid it. I'm overseeing 2 students who are doing wonderful research papers on, first, everything that the Obama administration did to try to avoid using notice and comment, maximizing use of the interpretative rule exception, the good cause exception, and the policy statement exception. And now, everything, even more, that the Trump administration is doing, because they've discovered that to rescind a rule or amend a rule, you got to go through the same incredibly painstaking, lengthy, resource-intensive process. And so what they're doing is everything within their power to avoid having to do it. It is not a quick, easy process. It is, I think, an appropriately difficult process.
Anybody else?
No, I do agree. I do think it's different. Thankfully, I think administrative legal scholarship, for most purposes, is it's a little bit less. There's divides, but it's not as thankfully not as bitter as our political process. Although you do get the sense that stronger critiques that were kind of on the fringe and dismissed 10 or 20 years ago as being kind of fringy, off the wall things, are now on the wall, in the sense that people are engaging them. Whether it's Philip Hamburger's book or Adrian Vermeule's book, maybe the temper of the times gives us a taste for more. I don't want to use the word extreme because that sounds pejorative, but kind of less outside of the mainstream. But I think the administrative law we've had over the past, the kind of halting consensus we've had for the past 30 years, recognizes these tensions between wanting to have the administrative state supervised and governed by law, while also recognizing the need for administrative expertise and try to hold these two things together in kind of a kind of common law, a compromise developed by common law. And what we have today on the Hamburger side and the Vermeulen side are attempts to kind of pull those two strands apart, to make supervision of law paramount, the rule of administrative state under law paramount with respect to Hamburger, or to have rule of administrative policy expertise and political accountability trump the annoying lawyers who get in the way of things. And so there's a willingness, and there's a greater interest in being able to kind of pull apart those two aspects of the compromise that have bound together. And maybe that's a sign of the times, or I don't know. That's my sense.
I remember a few years ago, Adrian Vermeulen and Jody Freeman wrote a piece called "From Politics to Expertise." Right, this was around 2007, talking about the ways in which the Supreme Court seemed to be giving increasing emphasis to the expertise side of things, and de-emphasizing the political accountability side of things.
Yeah.
And I mean, so much of administrative law is a balance between political accountability, technical expertise, and rule of law values. And I'm wondering, do we see a significant shift in the court on that balance, or do you think that maybe the current balance, I mean, as a neoclassicist, I guess you'd say it's time to give more emphasis to the rule of law side of things. Just wondering how that balance would continue to be struck over time, or maybe it's time to just fundamentally reconsider this. And my own 2 cents would be, if Dick's right that so much of this is informed by this sustained political gridlock in Washington, especially in the legislative branch, then wouldn't it be important to elevate the political accountability side of things and make the regulatory agencies more politically responsive?
No, I think you would do what Dick is describing by saying the reasoned decision-making paradigm circles around or avoids having things reduced to the sharp political polarizing issues, that the court can maintain something that it thinks of as the rule of law, and I think has some correspondence to the rule of law, by saying certain neutral expectations can be maintained, and instead of reducing decisions to political choices that are going to be fiercely controversial, here are some standards we can apply more broadly. So I think the reasoned exposition strand of administrative law that Dick talked about quite well probably has staying power. At the same time, I believe we will see these constitutional challenges renewed. And just look for a couple. I mean, Aaron's exegesis of where we are right now has force, but also think about a couple more years of Trump or Pence appointees. You're going to see people who will be pressing those arguments, and those challenges will be high profile. To tie this back to where we started, I foresee them happening, but I think a lot of it's been cloaked in originalist rhetoric that is not persuasive to me. Justices Scalia and Gorsuch, in their challenges to deference, rely on the purported intentions of Congress in Section 706, the proponents of the Separation of Powers Restoration Act, to overrule legislatively Chevron and Auer, and maybe more hark back to the supposed intentions of Section 706. And I view that as kind of a false front for things that have other justifications, but that ought to be put more candidly on the table, instead of putting it in a frame of restoring the integrity of the APA.
So last year, in November, I presented a short paper on what administrative law would look like if Chevron went away. And it was more kind of an analytical paper as opposed to an advocacy piece. It was at the University of Pennsylvania, and it was election day. It was a kind of legislative, statutory interpretation, legislative process, workshop seminar for students. And because it was an election day, and electioneering is an excused absence, there's about 50% of the people there, right? and they're out canvassing. And one of the questions I had is, well, is this ever going to happen? Like, is the court ever going to, are people ever going to really kind of rally around getting rid of Chevron deference? And I said, probably not, like, unless Trump gets elected. And then we all had a good laugh because no one thought that was going to happen. So I don't think this, there may be good arguments for against APA originalism, and think if you're just not a originalist, right? Or if you think the APA originally was intended to be a living document or something like that, or it's just functionally bad, there are good arguments against it. But I don't, when you're a critic of Chevron deference under President Obama and President Trump, I think it's hard to say, I think it's hard to say that it's kind of a rhetorical front for a larger ulterior project. So,
Anybody else?
Can I just chime in real fast? I had a question for Jeff, and that is, it seems to me that your paper is backwards a little bit under ordinary rule of law principles, which is stare decisis says statutory interpretations are the strongest, and constitutional interpretations are the ones you're more willing to reconsider. But your analysis is exactly flipped, where we're going to say that the constitutional holdings are fine, and we're going to not use stare decisis for the statutory holdings. And that just seems, I'm not sure, what's your answer to that?
yeah, so that's a great question. And I think one way of going about it is these statutory arguments are kind of, on the one hand, it's more modest, the call to if you were to knock out the constitutional stare decisis, the statutory decisions just go away, right? When you are knocking, if you're going to be flexible, if you have more flexibility with respect to constitutional law, and you reach the conclusion that the administrative is unconstitutional or something like that, all this kind of APA stuff kind of comes down like a house of cards anyway, right? You kick it out from under, right? And so that would be, if you do the constitutional thing, you're essentially kind of doing the statutory stuff as well. And secondly, to the extent, and then there's kind of, is stare, if we're going to kind of apply our kind of Casey factors for stare decisis or something like that, as Dick said, like the law of deference is a mess, right? It's not clear how stable a framework we have. With respect to the procedural stuff, the Supreme Court, on Vermont Yankee and Perez has been pretty straightforward about what the APA means, and it hasn't. I don't think they've blessed the other aspects of what the DC Circuit's doing. And then, I think the the hard look stuff would be more of a challenge with respect to statutory stare decisis. But I guess my point is, if you go Constitution first, the whole edifice goes away, and it possibly goes away anyway. So.
Well, I mean, that would depend on the constitutional holdings.
Yeah.
But if it's, say for instance, it's adjudication, and they say, we're not so sure that private rights can be adjudicated in Article 1 or non-Article 3 courts, that seems nothing to do with whether or not hard look review would be okay.
Yeah, no, that's
it
true.
seems like those are just analytically distinct.
Well, I'm sorry to cut this off. I do want to give our guests in the audience an opportunity to ask some questions. We have about 10 minutes left. There's 2 microphones, one on each side of the room, so if you have a question, please raise your hand. Wait for the microphone to come, and please identify yourself. This is being taped for future viewing online. Do we have any questions? We'll start here, and then the second one there.
Hi, I'm Cindy Crawford from Cause of Action Institute. I want to present to you another theory. Sorry, is that better? Another theory of deference, and see if any of you have given this any kind of consideration. Not an official theory, so this is sort of a de facto. In private practice, if an attorney were to go into court and present evidence that the attorney either hadn't investigated or knew was false or misleading, or actually related to a different party rather than the party in the case, the attorney in private practice and the attorney's client would potentially be subject to sanctions. When the party is a government agency, there doesn't appear to be any recourse in the sense that it's few and far between, if ever, that the government attorney is held to the same sort of evidentiary standard as the attorney in private practice. The effect of this being that as more garbage is thrown into the system, more of it makes it into the sausage at the end. And so I wondered if any of you have given this any sort of consideration, or if you're aware of any studies on this topic.
Well, I am aware on the studies on the topic of going after government attorneys. And Nick Perello is in the audience, and he's going to present later, and he is the leading person on that. I think he's read every single case that's ever been written where they've tried to hold the government in contempt for one of these sorts of things. So talk to Nick on that part of the question. On the other part of the question, I'm a little bit confused. So what are you saying? What are they throwing in that's improper? You're saying that they're not looking at the right party, or so? I don't understand the question.
Okay, so if you're interested in this afterwards and you want to look at an actual example, I would direct your attention to a case that's pending before the 11th Circuit, which is FTC versus LabMD. But just generally speaking, it's in private practice, there's a restraint on the attorney against presenting evidence that the attorney knows or should know doesn't have evidentiary support, right?
Mm-hmm.
That's either not what it appears to be, or it just simply doesn't apply to that defendant. And so there's a selection restraint on the attorney against presenting things that the attorney knows the court shouldn't be considering.
Mm-hmm.
But when there's no effective recourse against a government attorney, that restraining principle is missing. And so you get more garbage going into the system, some of which will end up getting considered and going into the final opinion because there's no fear, basically, of having to take responsibility for presenting things that are improper.
Yeah, okay, I see the point. I don't know anything about the case, so I can't speak to what happened in that case or not. But yeah, government lawyers are still lawyers, and they took an oath. They're still members of the bar. If they're doing sanctionable things, then they can be sanctioned, though Nick would be the chapter and verse guy as to how that actually works in practice.
Nick is going to go through what happened and didn't happen as a formal legal matter in a lot of these cases. In one of them, I took a very in-depth look at what happened to the individual lawyers. There were 88 lawyers who were held in contempt by one judge in one case. And in many, many cases, it was a career-ending move.
Which case was that?
It was Judge Lamberth presiding over the Department of Interior Indian land claim case, where he held 88 lawyers, half of them at DOI and half of them at DOJ, in contempt, sometimes because they would they would offer theories that he found to be unacceptable.
So we had a question right here, and then, are there any others? And then next, right here.
Hi, Max Smith from the Nuclear Regulatory Commission. Can you hear me okay? Great. Chief Justice Roberts' dissent in Arlington puts me in mind of then Justice Rehnquist's separate opinion in the benzene case, American Industrial. There he argued that he was motivated by a lot of the same concerns about too much power accumulating in the hands of administrative agencies, and pointing to the non-delegation doctrine from the New Deal era as a potential solution to that, where a legislature can't delegate important policy considerations to agencies, and when it does delegate, it has to do so along the lines of an intelligible principle. With this new interest in looking at deference, do you see the non-delegation doctrine as pointed to by Justice Rehnquist as a potential area for further exploration, or is the dustbin of history pretty firmly shut on that?
Well, of course, his opinion was, in a sense, the end of the decade-long debate that included Ted Lowy and John Ely, lots of people were arguing for reinvigoration of the non-delegation doctrine during that period, and it died, I think, because eventually there was a consensus that there was no justiciable standard that could be applied on a consistent basis. And so since Justice Rehnquist's plurality opinion in Benzine, the Supreme Court has upheld against non-delegation doctrine challenges 6 different statutes in quite different fields of law. So it doesn't look like there's any appetite on the court for that. I will tell you that an exchange I had with then Professor Scalia back when he and I used to exchange drafts of our writings before we published, and I sent him something where I said a lot of distinguished people had argued that we should reinvigorate the non-delegation doctrine, and I included a footnote to something he had published in Regulation magazine. And he called me and said, no, I never said that. So I read him the sentence, and he said it. And then he said, here's what I meant. He said, of course, I agree with you completely. It's ridiculous to think that we could come up with a justiciable standard that could be applied across the board that would make any sense. And what I really think we should do is the court should, every 50 years, take some statute, any statute at random, and just fire a shot across the bow of the Congress and tell those jackasses they're supposed to be doing a job and they're not doing it. And I don't give a damn what statute it is, but we need to do that every 50 years just to remind them. But of course it can't be done on a systemic basis.
He actually did say that in Regulation magazine also, and not just to Dick. But to answer the question more directly, no, I don't foresee the non-delegation doctrine being revived as a formal matter, but I do expect justices and judges to keep referring to it as though it had some potential existence in order to justify other things they want to do. That's pretty much what the Arlington dissent was about, was saying, oh, it's so terrible that we have this broad delegations, and so let's come up with something else to impose restraint. I think there's a recognition that you can't do without broad delegations in a society of 300 million people where Congress can't make all the decisions. Justice Gorsuch as well, in his opinions, Judge Gorsuch's opinions, contain that same kind of passing reference to non-delegation as though he was going to do something about it, but what he wants to do is something other than revive the doctrine itself. So I think it will continue to have the shadow existence and no force as an actual constitutional holding.
I do think that's the source of the big concern. That's why so many people are very concerned about the administrative state.
So I thought we'd have time for another question. I'm sorry we don't. We're up against our time, and I want to keep us on schedule. For a conference titled Beyond Deference, we've now spent the morning talking mostly about deference, but in the next panel, we'll get truly beyond deference. We'll get beyond it with a panel on when should courts step in and how. That's at 10:30, and we'll break for 15 minutes. But thank you very much to our panelists.